Hey guys, it's Kathy. You shouldn't be here. this is gonna be a shit show stream because just testing my brand new fiber internet connection. Fiber, the real fast stuff. It's all right. Living in Lancaster has really good perks. I live right beside Hershey's, Dove, Ghirardelli. This is gonna get me through this stream. I don't even know what I'm watching. So I don't know if it's good, bad, or ugly. I don't care. I just want it to freaking play. That's not too much to ask for. I just want this video to play. And I'm going to use chocolate to get me through this. Oh, there goes my earbud. I got sound. It's playing.
Yeah, this is working.
People v. Jesse Groves, case number 25S19267 FC.
Awesome.
The present person has his.
I picked a video with excellent audio.
Attorney, Mr. Lewis, is
I did.
a 34/7.
Of course I did.
Copy of the.
Lewis, if you had the adequate opportunity to review the consent report and send the information on.
I need to address that, Your Honor. Mr. Gross, you represent Mr. Downs, correct? Yes, sir. And I'm subbing for him, and that's okay with you? Yes, sir. It's my understanding, according to my notes from Mr. Downs, he went over the PSI with you. Yes, sir. And I talked to you about it a few minutes ago. You indicated, and he's indicated there's no changes to the report. So that's what you're speaking. Yes, sir. Thank you. We're ready to proceed here. I know no challenges.
All right, Mr. Butler, do you have anything on behalf of?
The agreement is Kilroot Capital Middle. The recommendation in this case is 24 months. The middle is 25. I believe that's the policy.
Lewis, what do you have on behalf of your client?
Your Honor, on behalf of Mr. Downs, I understand that the middle of the guidelines are 25 months, and that's what the recommendation is. I'm going to ask the court to go to the bottom end of the guidelines for various reasons.
Guess who just called me? My internet provider. They're sending someone out today. But we're going to play. We're going to keep playing and see, because I did a bunch of stuff. I mean, I can do stuff. I can do stuff. So I did stuff, and I'm going to test it.
Since he entered the plea, he's had no misconducts. It goes well for him. Sometimes people do. Unfortunately, he's had 20 misconducts in the last 6 years, but as you know, that there are a lot more prisoners. It's got a lot more than that. So.
Yep, Judge, he only had 20 misconducts. So there's people with more. He's fine.
And then he admitted to having possession of the weapon. He did not use it at all. He's currently in level 2. Hopefully, honestly, we'll give him some sort of a break here. He's putting in and trying to participate in any programs when available. So again, I'd ask you to go to the bottom end of the guidelines.
Mr. Gross, anything that you'd like to say before the court imposes sentence?
Sir.
All right. So everything that's been stated here is accurate. You have 4 prior felonies, 16 prior misdemeanors. Since being incarcerated, you have those 20 misconducts. You have a guideline range of 14 to 36. Recommendation here for the middle, and that's your agreement that you have worked out with the people. Court finds that that's an appropriate recommendation based on the information contained in the PSI. So I am required, and I will impose a $68 state cost that's required by statute. Also required by statute is $130 cognitive assessment.
$68 fine.
Court costs of $300, attorney fees of $400. Consistent with your agreement, the court will impose a sentence of 25 months. That's a minimum sentence. Give the Michigan Department of Corrections to statutory max of 7 years, 6 months. Without receipt credit for any days that you previously served as a result of your status at the time the offense was committed. And then also, the sentence must run consecutive to any sentence that you are currently serving. Now, you do have a right, sir, to seek appellate review if you'd like to do that. You have 21 days, today's date to make that last. If you want a court-appointed attorney to assist you, you have a broader window of 42 days, so 21.
I'm giving you the copy of this public rights to be signed, giving the other copy to the officer.
All
If you
right,
could
so
ensure
we're
they
placing
get
that in
started
the
out.
file. You're all set today. Good luck. Thank you. Officer.
Thank you.
Okay, I had some chocolate, so when he comes today, he'll be safe.
Drags, Stefan Drags.
Safe from harm. It's my internet provider again.
All right, this is case number 24S19170FH, People being Drags, defendant present in person as is his attorney. Mr. Peterson, today's the time for status conference. State the offer for the parties wish.
Yes, please.
The offer in this case for the
The
defendant
judge already looks
to the
pretty
charged
annoyed.
offense, we dismissed the individual's second offense, we killed group.
I get it. I'm pre-annoyed all the time, Judge.
Cap, middle of the sentencing guidelines, plus 2 months of the PSI. Anytime sentence to be consecutive with the current time served within the city, for 25 spots.
What your client want to do?
I believe we are here to enter a plea today, based on the topic.
All right. Then you are, in fact, Mr. Drags, is that right?
Yes, sir.
If you do the best you can to raise your right hand, that clerk over there is going to have you sworn.
You do swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
All right. So, Mr. Drags, the amended information I have in front of me has one count of
While we're watching this guy, I need you to know who you want me to go to next. We're going to do one more after him. Should we do him? Should we do him? Or should we do him? There are 11, 12 people watching. So it's not going to be hard to get a majority vote here. All right, let's make it easier. A, B, or C? Which one? Which one should we choose?
prisoner, cell phone violations. It's a 5-year felony and or $1,000 fine. You understand the nature of that charge and then the maximum time.
I think I do.
Okay, well, when you say you think, they're alleging that you had a cell phone as an inmate of the Department of Corrections. That's against the law. Does that make sense?
Yeah, what about the 5-year part?
And the maximum penalty is up to 5 years. Now, they've just placed on the record your agreement with the people, and I don't recall what that was, middle?
Yes.
I don't remember. So your agreement is the middle of the guidelines, whatever that may be. So I don't know that the attorneys have run those guidelines. We won't know what they are until the DOC runs them, but your agreement is it will be no worse than whatever the middle of the guidelines are. You understand that?
Yeah.
Okay. So if you want to go forward with this plea, then you'll be waiving the right to have a trial. Is that what you want to do, is waive your right to have a trial so you can take advantage of the offer that has been worked out on your behalf?
Yeah, I'm gonna wait.
Okay, so when we waive our right to have the trial, then you waive all the rights that come along with the trial. I have to describe those for you, so bear with me. Waiving your right to have a trial, not having it, in other words, means you're waiving the right to be presumed innocent of this charge. It means you're waiving the right to confront any witnesses that would be called against you. It means you're waiving the right to call your own witnesses. You're also waiving the right for you to testify at a trial or not say anything, and that couldn't be used against you. It also means you're waiving the right to have the assistance of an attorney at the trial. You've got Mr. Peterson, so he can stay with you throughout a trial if that's what you wanted to do. Are you waiving all the rights you would have if you wanted to have a trial? Okay. 2 more things you'll be waiving we have to discuss. The first one is this. By entering this plea, you'll be waiving the right to claim at a later date time then it wasn't your choice to enter a plea this morning. You understand that? Okay, and then you'll also be waiving the right to claim at a later date and time that there were other promises or threats or inducements to you except those we've already placed on the record. In other words, everything that you are basing your decision on entering this plea.
So we hear him say this. You waive this right. You are not allowed to do this later. However, we watch habeases from Georgia here all the time, only on this channel. Other channels don't show these, but we watch these habeas cases all the time, and that is exactly what they argue. And sometimes they win. Sometimes they win, sometimes they don't. But this is all bull. We know.
Has been placed on the record. Do you understand that? Okay, yeah, we're recording this, yeah. Okay. You have any questions about anything we've covered so far?
Yeah, before I take the plea, I just wanna know that by me taking this plea, there's some things that I don't agree with that was said, and some other charges be brought up against me because I'm taking this plea.
Well, I only see the one charge that you're
Absolutely,
facing
yes.
here, and I think that's,
I'm saying some things in the police.
If I plead guilty for robbing this bank, can they charge me for breaking the window to get on my way out too? Because if I plead guilty, then they shouldn't be allowed to charge me for other crimes, even though I committed them.
Or that was said that,
Oh.
I vehemently disagree with.
so as it relates to sentencing, the police report is not part of a pre-sentence report to the extent that they'll be including different statements from the report. That's for you and your attorney to go over before the sentencing date. And he can then address those at that time. They can be stricken, they may not be stricken. It all depends on what it is, okay? Any other questions?
That's pretty much it. I just wanted to be known that I'm pleading guilty to using a cell phone while I was in prison. Nothing else.
Yep, that's what this says.
Yeah.
Okay. So then let's talk about the charge. How do you plead to the charge of cell phone violations being a prisoner?
Pleading guilty.
Okay, the information says this occurred on or about April 10th of 2024 in the township of Easton, county of Ionia. Got the correct date and location?
Yeah.
On that date and location, can you tell me in your own words what you did to be guilty of that crime?
Came to my room, and then they called me cell phone on my bunk's bed. And once they entered into the cell phone, they seen pictures of me inside of the phone. So
Okay,
they were saying, but they're alleged that
I don't know what he said, but I think he said he tried to smuggle a cell phone into the jail. So we have a vote for A, a vote for B, a vote for C. Just so you know, that means I pick. So I have a way that I'm going to pick too that will find us the best one. Who are we going to next? A, B, or C? And if you guys don't pick one, I have a no vote right now. I have a vote for A, B, and C. So that's a no vote. So if you guys don't vote, what I'm going to do is I'm going to lightly listen to each one of them and then go back and go to the one that I like the best.
I had the phone in my hand that I dropped it, but that wasn't true.
was found in your cell.
It was found in my cell.
All right.
On my bunk's possession.
And is it accurate that at the time that was found, you were an inmate lawfully confined in the Department of Corrections?
Yes.
Okay. Mr. Butler, anything else on the facts?
No, thank you.
How about you, Mr. Peterson?
No, thanks.
Okay. Back to you, Mr. Greggs. Other than what we have talked about here this morning on the record, has anyone else promised you, threatened you, done anything to you to get you out of this plea?
Probably Micah.
Other than what we've talked about on the record this morning, has anyone besides your attorney said anything to you about what your sentence might be as a result of entering this plea?
No.
All right. Mr. Butler, are you aware of any other promises, threats, or inducements to Mr. Greggs?
People are not,
How about you, Mr. Peterson?
I am not.
And then Mr. Butler's court complied with the court rule for taking this plea?
Yes.
And Mr. Peterson?
Yes, I believe it has.
All right, finally, back to you again, Mr. Gregg. Do you have any questions now that we've almost completed this process about this plea taking process?
No, just, when how my sentence is gonna be.
That's gonna be about 4 weeks, so we'll get to that in 1 second. So last question to complete the process. Do you want the court to accept your plea to this cell phone violation crime?
Yes.
I will accept your plea. You did offer your plea freely, accurately, and voluntarily. All right, so we need a pre-sentence report before sentencing. We've just referenced this a couple times. That's gonna take about 4 weeks to be completed. Once it's completed, Mr. Peterson will have a copy of it. He's gonna have a chance to get it out to you or read it to you on the phone, whatever works. That'll happen a day or so before the sentencing date, okay? And then, you two will have a chance to go over it, to check it for accuracy, okay? And your question earlier, if there's information in there that you object to, he can raise it on your behalf. It may not be successful, it may be successful, I don't know, it depends on what the objection is and what it involves. But 4 weeks will probably get you back here in that time frame for sentencing, okay?
Okay, who wants to guess? Do you have any more questions? Yeah, well, will I get this in writing? Or he's gonna have a question.
Anything else from either side?
No.
All right, you're all set today, thank you all.
Good job, he didn't ask a question.
Yeah, you're gonna come to jail and see who that is.
Who do we have in the jail?
Okay, for the third time, for the third and last time, it's already too late because we already voted for B. We were either going to A next, B next, or C next. We got 2 for B, so they won. So that's where we're going. We're going to try to find B. Although A looked pretty good. A is still going. Hold on. We might go back to A instead. All right, now that was B? That was it? Hold on. That's A. This should be B right here.
There you go.
Yeah.
I think got you now. Okay, Portland.
Yeah, so we're here for a status conference today, and I can go ahead and recite the offer. The offer in this case, the defendant pleads guilty to count 1. First degree, count 2, receiving and concealing of stolen property, specifically motor vehicle, and count 3, UDAA. We reduce habitual 4 to habitual 3. We kill a bruise sentence in the guidelines, we find cost restitution PSI.
So what's your plan like today?
Well, I believe at the present, his intent is to proceed to trial. Is that correct, Mr. Orton?
Yes, sir.
Okay. And also I'm wondering if, how serious are we on motion deadlines, Judge? Because the scheduling order would put the 45 days at the end of this week. Keep in mind, I didn't get my prelim transcript until April 4th. But I'm working on a motion right now to address a bind over issue. So I'm wondering if I could have maybe until at least the end of next week.
So any objection to a week extension?
No, it's not scheduled for trial.
So let's just make sure that we put that in the form of an order run by Mr. Butler for approval and then to the court for signature. Okay.
Okay.
I'll to make it 2 weeks then, since we don't have a scheduling date yet.
So 2 weeks.
Yeah.
Or to 19244. And scoring categories like to address will be 1, 2, 3, 10 for that.
So you
the
said
domestic-
OB1?
Yeah, for the domestic violence count.
Go ahead.
All right, so on this one, I would argue that there should be no points assessed. This is a McGraw variable. So the
I
sentencing
can't
offense
hear.
police control, which in this case is domestic assault, domestic violence. Of course, there was a charge for felonious assault and dangerous weapon and felony firearm, but those were dismissed part of the plea deal. PSI itself does contain information that would justify finding and scoring the domestic violence without invoking use of the firearm. statements such as Mariah advised Jeremy to hit her on the head, later he began to choke her, had her in a headlock, squeezing her neck, so on and so forth. And also, I'd point out, it,
Looks like we're back.
So we're gonna pick up, I guess, right where we left off, and essentially what I'm saying is there are facts in record here that do support the ability to find and score the domestic violence without invoking a dangerous weapon. And of course, his plea did not provide, as far as facts coming from the defendant, did not provide a basis for use of a weapon because he pleaded simply to use domestic violence. And his account of the events was something along the lines of, you know, she pushed him and then he pushed her back and she fell down or hit her.
So she pushed him first. He pushed her
All
back.
right,
Hi,
so who
man.
wants to go first, probation or the people?
We'd like to take out the-
Your Honor, I would just score based on the fact that she reported that he put her in her head, she was set up a shotgun, that he did point to her head, it was just about him.
I can't hear it.
I would concur here.
Internet is
Ms. Peterson,
strong.
do you believe that this LaCroix case supports the idea that without actual basis from the defendant, I guess I'm trying to paraphrase here, it can't be scored.
Okay, so the citations from across simply stands for the proposition that, of course, it's the sentencing offense that will control the score. In this case, the sentencing offense, domestic violence, third. And so all we need are facts that would support that. We don't need to invoke the use of a firearm.
Hold on, but I want to understand.
Wish it was stronger.
For purposes of the plea, that's all the facts you.
He reminds me of like a bingo troll.
But it's all you.
I love
all
them.
we
I
need
love
to
them.
score is what- Now, this stands in contrast to, by example, the people who Shomaki case. In that case, the similar points were scored for holding a BB gun to somebody's head. But they found that that was appropriate because it occurred during the scope of a kidnapping, which was. Now, in this case, here, what we have is, as described in that section there, where she says that we hit her in the head, you know, choked her, squeezed her neck, had her in a headlock. If those things are all being done without a firearm in his possession, that's even assuming that the felonious assault did occur, then it ended by that point, because you can't, it'd be very difficult, maybe impossible for him to be holding a shotgun, choking somebody out, putting them in a headlock, doing all that. So
Doesn't domestic violence entail something as simple as an assault? Reasonable apprehension of a battery, that can be charged. I think the facts here certainly support that.
yeah, there are plentiful facts to support it. So what I'm saying is, we don't need to invoke the use of a weapon. We don't need to score that. That's what I'm saying.
I'm not certain that I understand the argument. The offense variables were designed to score conduct for all charges here, all of our statutes that surface in the course of committing that crime that are in essence aggravating in nature, that support scoring for purposes other than the offense, that are in addition, I should say, to the underlying offense. Here, we clearly have statements from the victim that a firearm was pointed at her. That occurred during the course of a domestic violence incident. That incident certainly could be as physical, let me put it that way, as assaulting her, choking her, pushing her. But it also, the definition of domestic violence can be as simple as a reasonable apprehension of an immediate battery. Pointing a firearm at somebody certainly would create an apprehension of an immediate battery. I don't think there's any doubt to it. I'm struggling to understand the argument.
So the last thing I'm going to do with Xfinity is make them run a speed test to show how much faster I am now than I was with them. They don't know it, but I thought it was funny. Bye, Xfinity. Goodbye. Yeah, that's me. I'm petty. Looks like the speed test stream worked, and it looks like I fixed the bugs. I might even call them and tell them not to bring the guy out later. Or, yeah, maybe I'll let the guy come out later. Oh, I don't know how I'm going to pay you.
If I understand the argument correctly, that the actual process of committing an assault would be difficult while holding a firearm. I don't believe so, other than the fact that this apparently involves a sawed-off shotgun, but I think that occurs all the time. Often the firearm itself can be used to commit the battery, pistol whipping, striking them with the butt of the stock. I recognize none of those things occurred here. But respectfully, I'm going to decline to amend the scoring on OB1. What else do you have?
All right, and since we've already put those out there, the argument for OB2 was coming, it was essentially the same, that had the court adopted my argument that they wouldn't score that at all.
So respectfully, the court will decline to amend the scoring on OB2. Certainly, the weapon that was reported to be involved here did have lethal potential. There's no doubt about that. What else do you have then? OB2 respectfully decline to amend scoring, and then what one?
Okay, so on OB3, it appears they scored 25 points.
Yeah.
That points category should correspond with essentially a life-threatening injury or exposure permanent type. So the scoring of 25 points is in error because in order to assess that on this OB, there must be evidence indicating that the injuries were in the normal course, potentially fatal in the absence of evidence suggesting the life was placed at risk, or more general evidence establishing that was suffered a by its nature life-threatening injury. 25 points is clearly erroneous. That's a quote there that comes from the case of People v. Cheney, that citations 327, Mishab 584, the page number is 591, and it's from 2019. Moving on, there is no direct evidence that I'm aware of that such an injury occurred here, or that treatment was even received. In fact, I believe she declined to be seen at the time that she was being interviewed for medical treatment. The only record evidence that I'm even aware of would be a statement to the effect of she felt like she had a broken arm, possibly a dislocated arm. She may have even said, oh. Beyond that, I'm not seeing any evidence that those injuries actually existed or were treated. So I feel like at best, this really would be more of a 5 or 10 point situation, certainly not a 25-point situation.
All right, probation.
Your Honor, the score basically that choked her, she had increased consciousness, suggesting she probably.
Did she say she lost consciousness or she almost lost consciousness?
She did have a raspy voice and very
Mr. Boswell.
So although all that is proved, I think I could state the victim did decline any type of medical treatment, even if her crime victim was one that she sent into our office, she indicated she declined that. So I don't believe it was raised level 25, I think probably 5.
I'll go with
All
30.
right, so I would concur with everything that has been said, and even the potential scoring of the 25 points. Certainly, I think would be appropriate.
I had chocolate. It's
if
better.
we had something subordinate from today. Not that that's always necessary.
He's
There's some
asleep.
sort of independent corroborating evidence. In this case, though, at least my, yes, I don't know that I could reach that conclusion. I'm going to amend that scoring. Certainly 5 points would be appropriate based on what I have. DSI, so we'll amend. We'll be 3 to 5. What else do you have?
And on variable 10 for exploitation of vulnerable victim. This one sort of confused me as well. I'm looking at the facts that are applicable here. We have a defendant who weighs approximately 150 pounds, to her about 140 pounds, maybe 135. Not
No, sir, you just victimized her again. You just said her weight in front of everybody. Are you stupid? Why would you do that? You could just say she's smaller. You didn't have to go there.
particularly more heavily built than her, considering he's about 5 inches taller. Now, as relationship goes, I believe she told police during the initial interview, and this would have been reviewed during the preliminary exam as well, so it doesn't technically exist in the record, that they did not have a relationship as such, even though she wanted to do one. The testimony at that hearing did eventually acknowledge there were a couple of sexual encounters, but nothing beyond that.
You weren't in a relationship.
So I'm gonna read you a quote here. The mere existence of one of these factors does not automatically render a victim a vulnerable victim. That's coming from the People v. Kenny, 481-152, pages 158 to 159. 2000. So Mariah called, she even called over a friend. It came in the middle of the night.
Can't
There
really
was,
hear.
this case involved like sort of a
I think they're trying domestic violence, but they weren't dating, and he choked her, and she weighs 140 pounds.
fight on one day afternoon, late afternoon, and then maybe another encounter the next morning. In between there, she called Robert Stark, who showed up, sat in his car for a while. And she chose not to leave, even though he offered to drive her away. Okay, so the point that I'm making with that is she had a support system of sorts available. She even invoked it, but didn't leave. She's not vulnerable in the sense that she's stranded geographically or anything like that. She just a poor decision maker at that point.
And she's a
To
poor
qualify
decision
for a
maker.
Domestic relationship for purposes of this category.
She's a 140-pound poor decision maker. That's what he just said right there. That's it. Yeah, what a jerk.
There has to be a familiar cohabitating relationship. Okay, that comes from the case of People v. Jameson.
You don't think engaging in sex might be familiar?
Judge, quit mumbling. We can't hear
I don't think
you.
there's anything necessarily cohabitating about it. No.
No, no, you could cohabitate closer than sexual intercourse.
Understand the word. Mariah lived in a
Judge is
camper.
annoyed, but I don't
and
know what
Jeremy
he's
lived
saying.
in a separate building. It's not a cohabitation.
So cohabitating is limited to their place of residence.
Yeah.
Okay.
So for terms of this category, the phrase dating relationship means frequent intimate associations, primarily characterized by affectional involvement or expectation. So I'm gonna pull an example here in the case of People v. Davis, which was referenced in the People v. Jameson. The Davis case itself was not published. They're looking at the factors such as that the pair spent nights at one another's apartments, spent time with family together. The defendant took care of the victim's son when the victim was away. And that's kind of things that invoke them to find that, yes, in fact, that's definitely a domestic relationship. You don't have any sort of facts and evidence for this case.
The friends with benefits just is never gonna rise to the level of relationship as that.
Functionally, I suppose so, yeah.
Okay, anything else?
No, I'm just,
Probation.
Okay, that was 4 days.
I'm not getting it.
Okay, hang on one second. So we got to, guessing that noise is from Saginaw County Jail. Who do we have at the jail in Saginaw County?
Troy Horton,
I didn't catch the last name.
Horton, Horton.
Horton, here's a who. Horton.
I still have no idea what he's saying.
Troy Horton.
Look how annoyed this judge is.
Doctor.
I
Yeah,
like
they're missing
him.
these hearings in the middle.
Okay, there it is. All right, so Mr. Horton, I've got to mute you, all right? And then
Yes, sir.
when we come back, there's getting a lot of noise there. We'll have to have you or an officer, like there's usually a speaker there, you just press the button, okay?
Sure.
Just hang with us.
he looks too respectful for me to pick
Okay,
C.
so AJ, you were saying it was scored based on his statements.
Yes, based on his statements, they give an incident with the victim multiple times. And,
Mr. Bob.
Yes, I would agree with that, and also what your honor's been honing in on, as well as the fact that although she was living in she was in a camper on the property, it's still the same property. It's still the same address. So I think there are two reasons that we can point to.
Okay, so he lives in the house. They are not dating. She lives in a camper on his property. Is that domestic relations? No. Domestic violence? No. No, I don't think so. They're more like neighbors. If you go beat up your neighbor, is that domestic violence? I don't think so. Why are there 3 people though? So we have this guy who started, prosecutor. Then we had that lady. And now we have this other man who was, I don't know. It doesn't matter.
All right, respectfully, I'm not going to amend the scoring there. Certainly believe that under this exploitation of a vulnerable victim, 10 points can be scored if there is a physical disability, mental disability, youth or ageing, a domestic relationship. I think that's what we all agree is occurring here, where the offender abused his or her authority status. The domestic relationship, no doubt that the PSI would support the idea that this defendant and the victim had been engaged in a minimum of a relationship that involved sexual intercourse on multiple occasions.
Okay.
Whether that's
domestic.
Characterized today as a friends with benefits, a more intimate relationship.
Wait,
that
what if he
is,
paid for it? Wouldn't that be like employer-employee, not domestic?
developed outside the limited purpose of sexual intercourse? I don't know. But certainly it's acknowledged by both parties that's what was going on. And also it is compelling to the court that they shared an address, all right, with both properties involving the same address.
No, I don't agree with that one.
Not necessarily a structure, if you will. I'm not certain how you characterize the places that they were at, but they were right on the same property, if you will. I think all of that creates an appropriate scoring of 10 under OB 10. What else do you have, Mr. Peter?
I think the other one wanted 25 and he's scoring it at 10.
The variables for that count, and then just moving on to the short bill shotgun count, I just have
Whatever
one
that means.
comment, and that's it. That would be on OB1 for the shotgun count.
I thought you said that we had.
No, this is the same case. We're just talking about the possession of short bill shotgun count now specifically.
Okay, so let's finish this one. All right, so this would reduce, we have 15 by 10 points, right? The OB third amendment. So we go from 70 to 60. Does everybody agree with that?
I believe we went from OB 3 from 25 to 5 points.
Oh, you're right. I scribbled it out. It looked like a 1 to me.
It's 50 and it still stays at the OB level 5.
So it does not change the OB level. So it does not then impact the ultimate.
I hope it was a
scoring of
puppy.
14 points. All right, Ms. Peterson, you concur?
Yeah.
All right. So now you want to address, this would be 25-19244FH, OB1, you said?
Yeah.
Okay.
Count 4. So again, this is going to be very familiar to the court at this point from the OB1 that we discussed previously. Simply based on the fact that when he entered the plea, he was copping to the fact that the gun was in his bed, admitting constructive possession at that point. So
Possession of a weapon of a felon.
I'll say again, it's not necessary to find that the gun was actually used in any particular way.
Okay. AJ?
Good, same thing. That weapons point further.
Well,
I would agree.
and I would concur with all of that. I don't know that the scoring of the defense variables is limited to the factual basis provided by the defendant, particularly when police reports then are included as part of the PSI background process, including, which I think does two things. One, it corroborates and or illuminates, I suppose, with additional detail to the crime itself. And it'll be 15, I'm sorry, it'll be 1, based on the PSI I have here, certainly would support a scoring of 15. Anything else?
No.
Okay, any other additions, corrections, or deletions as it relates to any of the 3 files?
No.
All right, Mr. Peterson, anything on behalf of the victim or the people? I'm sorry, Mr. Butler.
That's okay, that's okay.
It's already been a long morning, we just started.
I know. Nothing on behalf of the victim. I don't believe that she's not present in court. I don't believe she's in Zoom either. And looking at this, the description of the offense, starting with the 241 FH case file, we have a rather low-level resisting and obstructing type situation. There's not violence going on. There's not struggles with the actual police or physical struggles with them. Defendant's in a bad situation there, but it's something you can definitely deal with. But then he goes on and picks up case number 244 FH. And what's interesting here is that this occurred on January 6th of 2025, as indicated by the PSI, at 2:00 p.m.
Are they
That was
building
the day and time it was
cabinets?
supposed to be at a preliminary exam for the 241 FH case file. It was supposed to be in district court at 1 o'clock on that day, January 6th. But instead, he was doing this. And this is really an outlier kind of situation. We're talking about a sawed-off shotgun, the level of assault to the victim in this case. And so he takes a very simple R&O type situation and blows it up into this when he's supposed to be at court anyways. I think that speaks volumes to the defendant, to his to all the things laid out in the PSI, and ultimately the recommendation in the PSI of 1 year and 11 months. So 23 months is the recommendation in this case, 29 months would be the top end. It's certainly within the Killigrew agreement. We would ask Your Honor at least sentence him to 23 months, if not up to 29.
Mr. Peterson.
Well, as for the 241 file, I would say simply, I agree that it's certainly the conduct that supported that was minimal. That this was simply somebody on one side of a wall saying, I don't want to come out, come back for the search warrant or whatever. Not physically. That one, I think, certainly would justify a minimal sentence, probably not even, if I'm being honest, I would advocate for not a jail or a prison sentence at all. However, the 244 cases, in terms of what's accused, is certainly more significant, quite a bit more. This is his first batch of felony cases, given his age, so some paradise problems can be provided in that regard. But he did break into it in sort of spectacular fashion, unfortunately. So, Judge, I guess we're kind of at the.
Then what about?
Gun to my head, I could not tell you who the prosecutor is because I don't understand. Like, it sounded like that other guy was the prosecutor. He went first, but he went first on the last case. All right, sorry, that doesn't make sense. The guy standing at the podium went first on his last case. This case, another guy went first, which sounded like the prosecutor because he asked for 23 to 28 months. And this guy said he doesn't want any prison at all. Except, that makes sense so far, but for this guy's last case, the domestic violence, he went first, and he sounded pretty much like a prosecutor that whole time. So, guys, I don't know what's going on here.
You, Mr. Johnson, anything that you want to say before the court imposes sentence?
Here we go.
Yeah, Your Honor, when this all happened, I was asleep. I was woke up. It was 11:30. I believe that 911 call was around 12 o'clock, if I'm correct. I woke up, my keys was gone, my wallet was gone, my phone was gone. That's kind of what started this whole thing.
That's my best nights when that happens.
I'm just on the regards of this happening at 2 o'clock in the afternoon. I believe that information is inaccurate. Like I said, I was supposed to be going to court, just like Mr. Butler said. I woke up, all my stuff was gone. I was trying to, sort it out and figure out what had happened. That's all I have to say, Your Honor.
Well, at the risk of asking, how does being woke up and finding your wallet and keys gone lead to a violent assault of this woman that you were involved with?
Well, when you wake up and your cell phone's gone, your keys and your wallet's gone, and there's only one other person in residence, you know,
You punch them.
one
I don't
direction
know.
would,
I
direction
don't
would
know how
go
that
one,
leads to a violent assault or a short-barreled shotgun in your possession.
direction would go towards, obviously, the other person, I would think, you know what I mean? If you woke up and it was just me in your house, what would you?
I would ask you, hey, did you take my wallet and keys? And you probably,
Oh man, I learned a lot today. Kids, next time you touch my stuff, I'm getting my salt off. You better not touch my stuff again.
deny it. And then I would have to determine whether I wanted you to live there anymore and then whether I was gonna call the police, but I don't know that I would assault you, choke you, and involve a short-barreled shotgun.
Well, if you came up, them are all, I'm alleged, you know, if you came up and took my glasses off my face and I pushed you, then you ran outside. You know, all this, that's all alleged.
Shut up, shut up, shut up, shut up.
Like I said, you know, that's on you though. I'm just
Okay.
stating the facts about the time. This incident happened around 11:30, not 2 o'clock. That's all.
I'm innocent
Thank you,
because I
Your
got the time wrong.
That begs the question then, why were you not getting ready to go to court if it happened about 11:30?
How was I gonna get to court, Your Honor?
I don't
Where
know.
my keys were going.
Well, where were you residing at the time?
Beside a bus stop,
Residing at 3598 Belding Road.
which is right beside the bus stop.
Right, what city is that in? Okay. And you've got what, 3 hours to get to court?
There at 1 o'clock.
Did you think of getting a ride or calling an Uber or something like that?
Taking a
Well,
bus.
like I
Ride
said,
All right,
they
Mr.
all,
Johnson. Here's what we have. Here's what we know. Pretty awful assault, dangerous assault, frankly. You
I
got
didn't
7
plead guilty to
prior
a shotgun.
misdemeanors.
That,
Just hang on, Mr. Johnson. Is there anything else you want to say? I'm going to give you the chance, but then I'm going to sentence you and I don't want to be interrupted. So anything else you want to say?
yeah, them are all alleged. That's alleged. I didn't plead guilty to assault with a shotgun. I didn't plead guilty to that. I pled guilty to having a shotgun in my possession. So that's all
what's in the
alleged.
police report.
That's all alleged. I didn't plead guilty to that. At the time of that sentencing, was I told that that was gonna be used against me? No. That's all alleged. That's hearsay.
It's hearsay. It's hearsay. Guys, that's what hearsay is now. This judge's facial expressions are worth it. Are worth it. The bad audio, no, it's not. Bad audio sucks.
There's no proof stating that.
There's no proof.
If I held a
In-
shotgun
in
to your
the
head,
police
would
report.
you stay the night? If I held a shotgun to your head, you were scared for your life supposedly, would you stay still? If you had a ride there to get you? Or would you?
I don't
leave?
know. I know there's lots of things that people do when they are constantly under duress from somebody that they have a relationship with that don't make a lot of sense.
But she states in the police report, right in the video on the cam, that she's in a relationship with Robert Starkey.
All right, Mr. Johnson, anything else you want to say
That's
before I impose sentence?
No, I'm good.
Very good.
I was just
Okay,
stating the time facts.
28 months. Here
that's
it goes.
fine. All right,
Talk him
so
into it.
as I mentioned, you got 7 prior misdemeanors. Mr. Peterson's correct. It is a positive that at age 40, you don't have any prior felony convictions, but as mentioned, this is a pretty spectacular way to get yourself into the realm of felonies. Again, it's a serious assault. Certainly involved the use of this weapon, no doubt about that. And it was a violent assault, even without the weapon being introduced into the situation.
A serious violent assault? Nah. One of you will get that.
And then we have the other case here with the R&O that, you know, would have probably been about fairly insignificant on its own if you had showed up to court and just taken care of it and then not involved yourself in this. So I'm going to impose a sentence that I think is appropriate. And the recommendation, at least in the court's mind, is appropriate. It's not the top of the guidelines, it's not the bottom of the guidelines, but I think it does account for you as an individual, your history, your background, and then these specific facts and circumstances involving these 3 cases.
That hurt my heart right there, guys. Thought that was good. I really did. That hurt. That one right there, that one was below the belt because that's fine. He's coming out this afternoon, or she. I'm not gonna lie. We really just he has to say the verdict. He has to give his sentence. I'm just gonna wait another second. Shush. Shush. Gosh. I think we're good now. I think it was the chocolate. You I'm not giving up. I'm gonna wait till he says 28 months. Right? Because that's what he's gonna say.
$300 in court costs, and then $130 crime victim assessment, again required by statute. On this charge, the court's gonna impose 1 year with the Michigan Department of Corrections to the statutory max of 2 years. It'll run concurrent with file 19244, and you do have a credit for 124 days you previously served. On file 25S 19244FH, again, I'm required to impose state costs, and that's broken down, well, it's a total of 136, broken down to 300, and then a crime victims assessment, again required by
If can you hear me? He got 26 months, guys. Can someone just tell me they heard me? Anybody? Anybody? Anybody listening? I tried to type it in chat, it won't let me. Okay, he got 26 months. I can't play anymore. It's done. This stream was a bad test. No, it didn't work. 26 months. Thank you so much for helping me test. You didn't have to. I hope you guys have a great day. It looks like the technician's going to be here any second. They just sent me a text, so I'm going to go now. Bye, guys. Have a good day.